Hey everyone, my name is Sahil Malhotra, and today we're going to keep it simple. As part of the trademark application series, I would like to review a crucial part of your trademark application process, the correspondence email and domicile address. An applicant for a trademark with the United States Patent and Trademark Office must submit the owner's email and domicile address. Correspondence email. The email used for correspondence depends on whether the applicant has hired a trademark attorney. Trademark applicants who have retained counsel of a qualified U.S. attorney may provide an email address as the owner's email, although all correspondence with the USPTO will be between the examining attorney at the agency and the applicant's attorney only. And trust me, your trademark attorney will thank you for it. The USPTO examining attorneys prefer to have only one channel of communication. The email provided in the owner's field cannot be the same as the email provided for correspondence. The owner's email will not be viewable to public, whereas the trademark attorney's correspondence email will. Trademark applicants without a U.S. attorney will need the owner's email and correspondence email to be the same. It is often advised that applicants create a unique email address only for USPTO-related matters, as the email an applicant provides to the USPTO for correspondence will be publicly viewable. Please be aware that an applicant is more likely to receive unsolicited emails due to the public nature of the correspondence email. Domicile address of applicants. A domicile is a permanent address with a substantial connection with the applicant. The address must be kept current throughout the ownership of the applied for mark. The domicile determines if an applicant must retain a qualified U.S. attorney. All foreign applicants must retain U.S. counsel. Now you might have a question, wouldn't a domicile address mean different for different entities? And you'd be absolutely correct. An individual applicant must provide either the business address or the residence address. A corporation should provide the business address, be it the state of incorporation or where it conducts a substantial amount of its business. A joint applicant must provide the address of each party. Do not lie. The USPTO will conduct a preliminary check to see if the address provided is related to the applicant's business. Suppose the provided address is of a third-party commercial mail receiving agency and is not the applicant's permanent legal place of residence or principal place of business. In that case, the applicant is almost guaranteed to receive an office action asking the applicant to clarify or correct the address provided, further delaying your application process. I hope this information regarding the trademark application process was helpful. If you have any questions regarding your own trademark application or other trademark issues, please click the link provided below to book a consultation. As always, thank you for watching. This is Sahil Malhotra.